we have Recuse, my lord and my lady, my lord friend, Mr. Emmanuel Bita. He appears for the, I believe, the seventh respondent. I don't know if he ever took instructions for the 10th respondent. The 10th respondent is Honorable, Abraham Kithure Kindiki. I don't know if he ever took. The last time we want to confirm if he ever did take. And I don't know if he appears for the
My Lord, I do appear for the first and third respondent.
Today we are having a Miss Grill. We have Judge Rima appearing online. Can you admit the judge? Judge Rima, good afternoon.
Honorable PJ, I can't hear you. I don't know whether you can hear me.
Yes, I can hear you. Good afternoon.
Yes, good afternoon.
Yes, we hope that you're in a position to join us comfortably.
I am ready for the session, PJ.
Thank you. Ms. Ambai, you are for which party?
My Lord, I do hold the brief for Mr. Paul Nyamori, Mr. Eric Gumbo, Mr. Moses Kugui,
You are holding who?
Mr. Ken Nikoli, and Mr. Ken Weli. Only for the first and third respondent. My Lord, I also hold the brief for Mr. Dr.
quorum sheet, and therefore I wasn't able to get listing of anyone else who may not have
Please speak loudly. We have Judge Rima who must also get what we are talking about.
I'm sorry, I figured that the microphone was capturing my voice. Nevertheless, I didn't have the quorum sheet, and therefore I did not know whoever should have appeared was to appear. We do not have any representation for any of the interested parties. That is Geoffrey, Gachagua, the first interested party, the Law Society of Kenya, the second interested party, and the secretary to the Intergovernmental Relations Secretary. Yes, my lords and my lady, what was to come up for hearing was the petitioner's motion dated the 28th of May 2025.
What is, not what was.
All right, what is?
Yes.
But in the intervening period, my client, who is present in court,
What is coming up was
the motion by the petitioner applicant, dated the 28th of May 2025.
yes.
In the intervening period, the petitioner applicant has instructed me to file the motion instant it is on the CTS. We furnish Malone Friends with a copy of that motion via email. I also shared on WhatsApp Messenger with such of Malone Friends that were present here. The thrust of which is dated the 1st of October 2025. The thrust of which is in terms of part 2 thereof, seeking the recusal of my lady and your lordships presiding this bench for the reasons that are alluded in the body of the motion, as well as explicated further in the supporting affidavit of the petitioner applicant. We would request, with tremendous respect, in deference to the upholding of the dignity of this honorable court, the faith in the administration of justice being fostered and upheld, that application be heard in precedence. I have intimated such of my learned friends that were here when in fact I came, that is a course of events that I would be suggesting, proffering, and requesting of this honorable court to adopt, so that then we can get the issue, is this bench going to go forth, or will it recuse itself from further adjudicating on these proceedings? My Lord, I don't want to argue my application, but if you allow me, the petitioner has laid the grounds to say that his faith in the administration of justice, dispensation of justice, in this particular petition has withered completely because his petition has been isolated when there are other similarly framed petitions raising similar issues. They may be worded differently, but the centerpiece and the linchpin of the consolidated petitions is the impeachment of the Honorable Rigathi Gachagua as Kenya's Deputy President and the appointment now of the 10th respondent hearing, Honorable Abraham Kithure Kindiki. Now, he perceives that he's being discriminated against and his petition has been isolated, kept aside, and therefore the danger that and the prejudice he stands to face is threefold. So that then you see the necessity to give these precedents that he will have had this particular petition not heard together with the other one, yet the Supreme Court has held in decision that I've cited in the body of the motion that where issues are raised of a similar nature, in saving judicial time, which is precious, and in enabling the courts to make a determined decision on all.
I don't think it's right for you to argue you have the question. What you have informed us that you have filed an application which is seeking the recusal of the bench.
Thank
I
you.
don't think it's in order for you to go ahead and argue it as if it's the application for coming for hearing. Now that you have said that, I want to hear parties because the effect of that application was probably engineered to derail the hearing which was going to take place.
My Lord,
So-
I beg not.
No, just sit down,
Yes,
please.
thank you.
We came here for a non-application dated 28th of May 2025. But by the opening statement by Mr. Kinanjui, he has introduced another application which is apparently engineered to deflect or to delay the hearing of this other application. You have stated it. I want a response from the respondents.
My Lord, my name is Emmanuel Bitter for the Attorney General. My Lord, we were served with the application this afternoon. It's an application for recusal. My Lord, an application for recusal, you know, has precedence over any other application. We will need to take instructions to respond to it. My Lord, we had agreed with my colleagues in respect to the application that was supposed to come up for hearing today, and we were ready to proceed. But because of the nature of an application for recusal, although it is our view that the court gives directions, and in giving directions, the court gives us time to respond to that application. That would be all.
My Lord, I'm ready for the first and third respondent to carry the 10th respondent,
Where is Mr.
Mr. Mbaya, for the first, third, and 10th respondent. We also confirm that you have been served with the application this afternoon by the Secretary to Nigeria. It's an application for recusal. My Lord, my lady, a perusal of the said application, the prior sort, particularly prior number 2, is more or less the same with the prior number 3 in the other application. But considering that the petitioner prays that this application for recusal specifically be heard first, we request this honorable court to give direction to enable us to take instructions from our client to file a formal response to the said application.
I wish not to reiterate the sentiments by my colleagues. However, Mr. Counsel Mbaya has pointed out something very important, that the prayer sought in the current application, which has just been passed to us, a plain reading of the same reveals that
Ms. Karanja,
yes, my lord. My apologies. Prayer C, in the application dated the 28th day of May 2025, is couched, or rather it is a veiled recusal application. In fact, when you read the body of the same application, it reveals grounds such as bias, which are the same grounds that are in the present application. My lords and my lady, we are concerned that the application as filed and served upon us today constitutes a facelift of the application dated 28th day of May 2025, and is indeed a dilatory tactic by the petitioner. My lord and my lady, we submit that we were ready to proceed with the highlighting of submissions with regard to the application dated the 28th day of May 2025. That will be all.
On behalf of the ninth respondent, we were indeed ready to proceed with the application that was slated for hearing today. We had filed in response our grounds of objection, our submissions, and our list and bundle of authorities, all dated the 7th of July 2025. Regarding the application for recusal that Learning Council for the Petitioner has referred to, we have not had sight of that application. We have not been served with the same application, perhaps because it was short notice or maybe an oversight on the side of the Learning Council. We'll be requesting service of the same application. And my lord, as rightly pointed out by Learning Council for the Attorney General, Mr. Emmanuel Bita, an application for recusal will automatically take precedence. We are ready to take directions on this.
Yes, my lords and my lady, on behalf of the 8th respondent, we similarly confirm we have not been served with the said application. Perhaps, my name is Obura. Yes. Perhaps counsel for the petitioner can serve us with the said application, and we'll take instructions on the response. I similarly echo the sentiments of my seniors that an application for recusal takes precedence, and therefore we are ready to take directions before you.
My friends, with the said motion on their email addresses. As I indicated earlier, had I gotten the WhatsApp messenger numbers from my friends, I would have equally given them, but they were not present as at that time. I didn't even know who was appearing for who, and that is because of the quorum sheet not being available. So really, there is no mischief or bad faith on my part. I need to emphasize that. As an officer of the court, under Section 56 of the Advocates Act, I owe a duty of responsibility to this court and to my friends to be faithful to that bona fides. Secondly, as indeed my friends have acknowledged, this is a standalone recusal motion. The previous motion dated 20th of May 2025, what is being alluded to is separate and distinct because there was a legitimate expectation on the part of the petitioner applicant that the consolidated petitions would be together. So it would be hard together with this particular motion. And therefore, the canvassing of that particular plea would then be in light of the other counsels being given an opportunity also to participate. And that's why it was worded the way it was worded at that time. However, subsequent to your order isolating this particular petition, the petitioner feels that that cannot adequately cover and canvass the issue at hand because it is the events subsequent to that that have provoked this application in the greater nation. So it is not right to say that that plea was raised and this now has been raised as a quote-unquote dilatory tactic. So I wish to differ with my friend on that point.
thank you.
Let me say lastly, although it is in deference to the right to be heard that a litigant files any application moving the court. So it is only just unfair that then this be ventilated. And because it was a standalone application, raising the plea in the application, then it ought to be canvassed. Thank you.
Judge Mrima,
Yes, President Judge.
because we are away, we cannot get your wisdom with us. We are proceeding to give directions. Do you have any contrary thoughts?
Honorable PJ, I believe this is a straightforward matter. We give directions in respect to that application. They file their responses and submissions, and then we proceed to fix the matter for ruling. There's no need of highlighting. This is a straightforward application. Thank you, PJ.
Not within my province to inquire with the honorable judge what he has said. But when you ask him to address you on his opinion, with tremendous respect to his lordship, the Honorable Justice Mrima, what I hear him say is that then there is nothing more but to give a ruling date on the motion dated 28th of May 2025. Probably I'm wrong. Or it could be read that he's saying that then we can proceed on the motion dated 1st of October 2025. I didn't hear him right.
What are you saying? What are you saying, Mr. Pinagi?
The directions of the court on this particular issue, which London Council have agreed to. They need to have a look at the application, they need to respond to it, and they also, we also need to have these take precedence over the motion dated 28th of May 2025. That's a clarification that I get from his lordship's remarks, because then I heard him say that what he's saying is that there's no hearing, we'll just proceed and give a ruling date for the 28th of May 2025 motion. Probably I misapprehended his lordship's directions.
You tend to hear things which in view of the application dated 1st of October, it obviously takes precedence. Your colleagues have sought for time to respond to that application. My view is we give them time, they file their responses, you file submissions, they file submissions, we fix that application for recusal for ruling. We do not need to hear highlights on that application. The result of my proposal is that the application dated 28th of May will be held in abeyance pending the outcome of the recusal application. I don't know whether I'm clear now, Mr. Secretary.
The application for recusal, of course, takes precedence over the application dated 28th of May 2025. Let that application dated 1st of October 2025 be served forthwith on all the respondents, if that has not been done. Get the addresses for all the respondents and serve it. The recusal application shall be responded to within 14 days. Respondents get that clearly. And thereafter, parties shall file submissions within 14 days after the responses have been filed. Beginning with the applicant. The applicant will have 14 days to file the submissions, and time shall be of the essence. After you file your submissions, the respondents also shall have 14 days to file their submissions. We will deliver a ruling on this application for recusal on 30th of November 2025.
Although with your kind permission, if you could grant me leave to file a supplementary affidavit.
Yes.
If need be.
Yeah, if need be, you can file a rejoinder. But those timelines are of essence. And we have deliberately made it like that because we are dealing with very urgent matters. So that we will deliver you a ruling on 30th of November 2025 using the pleadings which are on record.
What's the date?
10th of December.
Very much obliged. My lord, my lady.